My name is Amy Laura Khan. I am the legal director for Taproot Earth, calling in from Mashpee Wampanoag territory in southeastern Massachusetts. I want to welcome you to Unravel and Weave, a webinar on the recent US Supreme Court term and its impacts on climate and environmental justice, rights, and democracy. In case you are not familiar with Taproot, I would like to first introduce you to our organization. Taproot Earth is a climate justice movement building organization rooted in the Gulf South. Our mission is to build power and cultivate solutions among frontline communities advancing climate justice and democracy. We envision a world where we can live, rest, and thrive in the places we love. We engage in movement building through three core solutions: acknowledging and repairing the harms of extraction and racialized capitalism, using facilitative leadership to build democracy, power, and frontline alignment, and advancing community stewardship and governance of water, energy, and land. We recognize that law and policy play a key role in each of these solutions. For that reason, we have convened the Just Transition Lawyering Network, a network of lawyers working to support Black, Brown, and Indigenous communities and movements, leading us towards climate justice and a just transition. We have launched the network as a space of information sharing, shared learning, and coordination, as one mechanism to build accountability with our frontline partners. And we envision the network as a community with heart for lawyers to build together. This webinar is an offering in that spirit. We hope this will be a part of a continued effort to build the network and our collective knowledge. An effort we're continuing in November with the Summit on Climate and Environmental Justice, Racism, and the Law, which will bring together organizers, lawyers, and scholars. I'm so grateful to all of the panelists for joining us, and I'm excited to hear you all in conversation. I'm particularly grateful to Andre Segura for joining us as a moderator. Andre is a vice president of litigation for Earth Justice and is based in Houston, Texas. Andre has been on the front lines of some of the most significant battles for civil rights and racial justice across the country. Prior to joining Earth Justice, Andre served as the legal director for the ACLU of Texas, where he led teams of lawyers to challenge the onslaught of threats to the rights of marginalized communities throughout the state. With that, I will hand it over to Andre.
Great. Thank you, Amy, and welcome to everyone. Thank you to Taproot for inviting Earth Justice to be part of this really important conversation today. We have a really exciting panel with four panelists who are bringing a diverse viewpoints and expertise in areas that are really important to our work and our goals throughout the environmental and racial justice and tribal movement. The way we're going to do this is that each of our panelists will have around 7 minutes. And you know how panelists can be with academics and advocates. I'll be watching the time carefully, and there's a lot to get through. So we're going to try to get through things as quickly as possible so that we can leave time for everyone to ask questions if you like. You can ask your questions. There's the question and answer option on Zoom that you can do that. So I'm going to introduce our panelists in the order they'll appear and what they'll be discussing, and then just kick it off. Our first panelist is going to be Kara McClellan. Kara is the founding director and practice associate professor for the Racial and Civic Justice Clinic, which provides students a hands-on experience in civil rights litigation working with Kara. And Kara brings her background as an attorney at the NAACP Legal Defense Fund, where she focused on education, equity, and ending the criminalization of Black people. Kara is going to be focusing on cases that were before the court impacting civil rights and racial justice. Our next panelist, Jordan Harmon, is the policy advisor to the Indigenous Environmental Network. She has extensive experience in federal Indian law, tribal law, civil litigation, administrative advocacy. Jordan earned her Native American law certificate and JD from the University of Tulsa. She also joins us from Tulsa. She's going to be focusing on issues involving Indigenous sovereignty and Indigenous rights. Our third panelist is Heather Tanana. Heather is a visiting law professor at UC Irvine School of Law. Much of her work focuses on tribal water issues, from the climate impacts to Colorado River management, and she leads the Water and Tribes Initiative's Universal Access to Clean Water project, which seeks to bring awareness to the lack of clean, safe, and reliable drinking water in Indian country and to make tangible progress on securing water rights for all Americans. And as her background demonstrates, she's going to be focusing on Indigenous water rights. And our last panelist is Andrew Mergen. Andrew is a visiting assistant clinical professor of law at the Emmett Environmental Law and Policy Clinic at Harvard Law School. Prior to joining the Harvard clinical faculty, Andrew was in the appellate section of the Environmental and Natural Resources Division at the Department of Justice, the US Department of Justice. He has extensive experience litigating these issues before the court, and Andrew's going to be getting into some of the legal questions, the doctrinal issues, such as major questions doctrine and other things like that, that we're seeing implicating a lot of environmental law cases throughout. So with that, I'm going to kick it over to Kara to start us off.
Hi, everyone. It's such a pleasure to be here, and thank you to Taproot Earth for the invitation to join this esteemed panel and for the work that you all do. So I have been asked to talk about Students for Fair Admissions v. Harvard and Students for Fair Admissions v. University of North Carolina. And I think it's important, before we even get into those cases, to talk about where the law stood prior to those decisions. So I'm going to give a quick overview of what we'd learned through a series of decisions through which the Supreme Court had repeatedly for over 45 years made clear that colleges and universities can consider race as one of many factors in admissions. So if we could cue the first slide. So essentially we have a series of critical decisions beginning in 1978 with Bakke, which was a splinter decision, but that ultimately becomes influential in really charting the course for what the Supreme Court eventually held through Gratz and Grutter and through Fisher was the standard for reviewing the permissible use of race in admissions. So essentially through these series of cases, we learned that colleges and universities can consider race as one of many factors, but it has to be what the Supreme Court calls narrowly tailored to serve a compelling government interest. And so first, we have to recognize there is a compelling interest in pursuing the educational benefits that flow from diversity. And although the previous cases were about public universities and decided under the Equal Protection Clause, the case against Harvard that was brought most recently was under Title VI, which governs recipients of federal funding, and so that extends this case law to private universities. So essentially, for private and public universities, we have been told over and over again through the case law that they can consider race to pursue the educational benefits of diversity, but it has to be narrowly tailored. So what does that mean? The court has told us through these decisions that to be narrowly tailored means that universities can't have a quota, they can't have an explicit number or set aside for how many underrepresented minorities they admit. They can't, in the court's words, insulate applicants from competition with other applicants, or, and again, I'm quoting the language that the court uses, unduly burden non-underrepresented minorities or white students. But the court can consider race as a plus factor and have a goal of what's known as a critical mass, or a overall targeting of ensuring that there are students of color on campus in numbers that ensure that they are insulated from tokenism and stereotyping, and also to ensure that everyone gets the educational benefits that flow from diversity. And there really is a rigorous body of social science research that has shown that students of all backgrounds really benefit from having racial diversity on campus. So that essentially is a brief overview of the law where it stood. And as recently as 2016, the Supreme Court had considered this question and had ruled yet again in Fisher v. Texas that yes, colleges and universities can consider race, that there is a compelling interest, but it has to be narrowly tailored through this framework. And so then after Fisher v. Texas, we see a new wave of challenges. These cases have been brought by an organization called Students for Fair Admissions, who is Students for Fair Admissions? So it's important to know that Students for Fair Admissions was founded by 3 people. One is Abigail Fisher, and if that name sounds familiar, it's because she is the named plaintiff in Fisher v. Texas. So after she lost before the Supreme Court in Fisher v. Texas, she was involved through Students for Fair Admissions, which actually was brought before the court even ruled on Fisher v. Texas, but already, individuals were starting to plot the next challenge to affirmative action. So she was one of the co-founders of Students for Fair Admissions. The other co-founder of Students for Fair Admissions was Ed Bloom. Ed Bloom is a former stockbroker. He has kind of been on a mission to challenge race-conscious admissions in different contexts. And then the third member founding Students for Fair Admissions was Abigail Fisher's father. So I just kind of provide that as some context for who are the plaintiff organization's leaders before we dive into the case. And I also just want to show a very quick video clip of Ed Bloom to really understand, again, the context behind this case. And so this is him speaking during an event at the Houston Chinese Alliance, and he really makes clear what he saw as the goal in Students for Fair Admissions, bringing these cases challenging affirmative action against different universities.
That's the goal of these lawsuits, is to eliminate the consideration of race or ethnicity in crime. So I needed plaintiffs. I needed Asian plaintiffs, and finding plaintiffs to challenge the Ivy League admissions policies, Harvard in particular, is not an easy thing to do. So I started, designed 3 websites: harvardnotfair.org, UNC, University of North Carolina, notfair.org, and UW.fair.org, University of Wisconsin.
And Ed Bloom really makes clear in this video that he had a goal of recruiting Asian American clients to join Students for Fair Admissions, that was his explicit goal. And I think it's also just important to remember that neither Abigail Fisher or Ed Bloom had previously advocated for Asian American, sorry, for some reason my phone is having a one of those Amber Alerts, had advocated for defending the rights of Asian American people in the past. So their focus has squarely been on eliminating race-conscious policies and remedies, really, for addressing discrimination and race consciousness in different contexts. And consistent with that, when they filed this series of cases, because it wasn't only against Harvard and UNC, it was also again against University of Texas, against Yale University, and it really was a series of cases against colleges across the country, in addition to those that I just mentioned. What they asked for as a remedy in these cases is an injunction against colleges and universities knowing or finding out the race of applicants. So just think about what that means, because it's pretty extreme language to try to have an injunction preventing colleges to find out the race of applicants. But it's also important what they didn't ask for, which is they didn't ask for remedies that were directly responsive to preventing discrimination against Asian American applicants. So the Supreme Court ultimately grants cert on 2 cases, the case against Harvard and the case against University of North Carolina. And there are 3 questions that were before the court. First, should the court overrule Grutter v. Bollinger? So again, a direct attack on over 45 years of precedence. Second, is Harvard violating Title VI by penalizing Asian American applicants, engaging in racial balancing, overemphasizing race, and rejecting workable race-neutral alternatives? Going back to where we started, again, this is essentially an argument that on the one hand, Harvard or UNC is not complying with the existing precedent that explains what is narrowly tailored consideration of race. But it also, as it relates to Harvard, was this separate argument about discrimination against Asian American applicants. That was not actually a claim in the UNC case, but it was a claim that got a lot of attention in the Harvard case. And then third was this question of, can a university reject a race-neutral alternative because it would change the composition of the student body without proving that the alternative would cause a dramatic sacrifice in academic quality or educational benefits. Again, that's connected to the existing precedent where the Supreme Court has told us what it means to be narrowly tailored. But in addition to challenging existing precedent, Students for Fair Admissions is also pushing the law to go beyond what was previously required. So we got a decision at the end of the 2023 term where the Supreme Court released a ruling in these cases. Just as background, they were originally consolidated, and then when Justice Jackson recused herself in the Harvard case, they were unconsolidated, but we ultimately get one opinion in both cases. So despite the fact that there was this question about discrimination against Asian Americans, that actually wasn't what the court's decision discussed. Instead, the court's decision really focuses on this question of whether it should overrule Grutter v. Bollinger, which was what the plaintiff has pushed for. So the court, in a majority opinion written by Chief Justice Roberts, does not explicitly overrule Grutter, and in fact says that they're not overruling Grutter. There's some disagreement about that in the concurrences. Justice Thomas says that the court is actually overruling Grutter, but the majority says that it's not. And yet still, we get this decision that is a significant clawing back at what we knew to be the precedent for over 45 years. So first, writing for the majority, Justice Roberts holds that, in his words, the educational benefits of a diverse student body are not sufficiently coherent for judicial review as they were used by UNC and Harvard. The court says that UNC and Harvard failed to articulate a meaningful connection between the consideration of race and the educational benefits of a diverse student body. Query, if you look at the record in the case and how much expert testimony and other social science research was brought in to show the educational benefits that both UNC and Harvard were trying to achieve, query how that could be the case or what could meet the court standard, but that's what the court rules. And then the court also has this language where it talks about how Justice Roberts and the majority believes that racial categories are themselves imprecise. Justice Sotomayor reminds us in her dissent that these same categories for defining race are the categories that we use for the census and for other federal policies, and yet we now have this decision saying that these categories are imprecise. I think it's one question to say, is race complicated and fluid, but another question to say that we can't use the categories that we have traditionally used to understand and to assess how to address and cultivate things like diversity. And so then the court goes on to say that it is not going as far as to issue a complete prohibition on colleges and universities considering the race of an applicant, but instead that the court is limiting colleges to only consider race as it is discussed by the applicant in terms of how they have been impacted by discrimination or inspiration or otherwise in their experience of being from a particular background. And so that is the law going forward. So I'm going to wrap up there. There's a lot more to say about this, but I want to make sure that we're mindful of time. Thank you.
Thank you. And I know there's so much to unpack in all of these cases. I was hoping you could just talk very briefly about how you see cases with racial discrimination playing out. Here, it seems like the court was unwilling to acknowledge the historical mistreatment of, in this case, particularly Black people in the United States, and to grapple with that history. How do you see that sort of line of reasoning playing out in some other cases, like say in the environmental justice context or other civil rights cases?
Yeah, I mean, I think we see a really concerning trend where, despite the context and also, I should say explicitly, the history of the Equal Protection Clause and other statutes that were really designed to address the inequality that flows from the historical legacy of slavery in our country, there is increasingly a hostility or unwillingness to consider this larger history and larger context, and to interpret civil rights statutes and the Equal Protection Clause as if they exist acontextually, right? As if we're just going to look at the language and have this limited understanding of what equality means without taking into context our history or the status quo in terms of systemic racism. And so we see this in the attack of disparate impact law, which I think we're going to talk about a little bit more later on. But I want to stress also, in thinking about the Supreme Court's decision in Students for Fair Admissions, one of the things that was most disappointing to me was to see the court really ignore well-established social science, really demonstrating the benefits of diversity, as well as inequality that exists in the K through 12 level throughout education in the United States, as if, again, we can think about college admissions as this one moment in a vacuum when students apply, without considering all the ways that race is impacting individuals throughout their educational experience, in terms of funding inequality, in terms of segregation, in terms of lack of access to resources like qualified teachers that map on to the racial composition of a K through 12 school. And so it's like that racial factor and racial inequality matters the entire time a kid is going through K through 12 education, and then all of a sudden we're supposed to close our eyes and ignore race on the moment that they apply to colleges and universities. So I think this is a quickly developing area of law, and we should take and understand this as a limited decision about college admissions and the consideration of race. But it is also true that it's emboldened Ed Bloom and other advocates who seek to limit the consideration of race in other contexts to continue bringing cases, including the cases that were brought by American Alliance for Equal Rights that are already working their way through the circuits.
Great. Thank you, Kara. I'm sure there'll be more questions after. So now we're going to switch over to Jordan to talk about the Indian Child Welfare Act and some other issues we're seeing in the Indigenous sovereignty area.
Okay, wow, thank you so much, Kara, for that overview. A lot of information about affirmative action. My name's Jordan. I'm Muskogee Creek from Tulsa, Oklahoma, and I began practicing law in 2017 in Indian law, representing tribes, and also doing a lot of Indian Child Welfare Act cases. And now I work as a policy analyst and legislative advocate at Indigenous Environmental Network. And I was asked to talk about the Brackeen v. Holland case and how that connects to environmental justice. And so for those of you who don't know, the Indian Child Welfare Act is a landmark piece of legislation that was passed in the 1970s. I can't remember the exact year. I think it was 1978. And it was passed because of this epidemic of assimilationist. It was a legacy of assimilationist policy where Indigenous children were being removed from their homes and placed in non-Indian foster homes at rates of like 80%. And maybe even higher than that. And so this law was passed to help keep Indian families intact, and it recognizes the inherent sovereignty of tribal governments to have jurisdiction over Indian child custody matters, and it recognizes the right of Indian families to be considered and prioritized for placement. And it also includes non-family members who are members of their same tribe. and Indian families after that for placement preferences. And so ever since ICWA is sort of like the abbreviation for it. Ever since ICWA was passed, there's been tons of mostly conservative, right-wing opposition to it. Think tanks, institute like the Goldwater Institute, huge organizations have spent decades fighting ICWA. And the reason for this is because, well, there is the family law issue. Some people are very passionate about the idea that the child's culture should not be considered. But also because of the core of the authority to pass a law like ICWA is based in this plenary authority that Congress has over Indian law and policy. And it's based in the government to government relationship that is the core of tribal sovereignty. And what the United States recognizes and what all of Indian policy is pretty much based on is this government to government relationship that started with trade and treaty making and now extends to essentially government policy. And so the first time and the last time that the Supreme Court had actually taken up an ICWA case was Baby Veronica, and this was in 2013. And back then, the court was very reluctant to actually completely overturn ICWA. And they had came up with some kind of like workaround, which this opinion was written by Justice Roberts, I think. And it was the intact Indian family standard. It has not really had that much of an impact on ICWA enforcement. It's kind of a shaky standard. A lot of states don't really know how to apply it. A lot of states kind of just ignore it. And it really hasn't had that huge effect that they were hoping that it would have. So now this most recent case is Brackeen versus Holland. This was actually out of the Fifth Circuit. And in this case, they had constitutional based challenges against ICWA. And a couple of the challenges, two of the challenges were based on basically states' rights. So there was the anti-commandeering argument under the 10th Amendment. And the court pretty much just rejected this argument. Federal Indian law is there's so much precedent stating that it is in the federal purview. It preempts state, any state action, and that there's this case called Kagama where the Supreme Court has announced that Congress has plenary power over Indian affairs and for years has upheld that precedent. So the court has been really reluctant to sort of revisit that. Okay, and they basically rejected that. They also made another states' rights argument under the non-delegation doctrine, and they chose not to take that one up. I feel that if they did take that up, it would probably be rejected for similar reasons. And the argument that really was concerning was the race-based argument. So they argued that ICWA violated the Indian Child Welfare Act based off of equal protection, and that non-Indian foster parents were being discriminated against because they were not prioritized under these placement preferences. And so this is the argument that puts the government to government relationship and all of tribal sovereignty at risk. Because if the court were to invalidate ICWA and say, no, having this designation, a special designation for Indian children, does violate equal protection, then that calls into question like hundreds of years of precedent in Indian law and the entire relationship that recognizes tribal sovereignty. One thing you should know is that the law firm that represented the foster parents in this case is Gibson Dunn, and they are a big oil law firm. They took on this case pro bono and represented them in the Supreme Court pro bono, and they are known for representing Transfer Energy and Enbridge and Chevron, who are all fossil fuels companies that where tribal sovereignty has interfered with big projects. So that includes like Enbridge is responsible for like Dakota Access Pipeline and Line 3 and projects that had, oh my gosh, sorry. There's a storm starting and the wind just blew something in the window. And so And so the race-based argument is putting all of tribal sovereignty and all those protections, including environmental justice protections, at risk. And that is kind of like the evil underpinning of these challenges, that there's this huge network, the Goldwater Institute, Gibson Dunn, fossil fuels companies, all these people that are sort of collaborating against this huge landmark protection, and one more thing, because I know I'm starting to go over time. The UNDRIP, the United Nations Declaration for the Rights of Indigenous Peoples, actually has a mandate in it that mandates countries to have a mechanism protecting Indigenous families, keeping them intact. They have a right to keep their children. And as far as I'm aware, the United States is the only country that actually has a mechanism that does that, and that's the ICWA. So I don't know why they would want to get rid of it when they're the only ones that actually have that mechanism. And so I'll check there, and you can let me know if you have any questions. So thank you.
Thanks, Jordan. Really surprising, but a grateful development in this case. How do you see either in your own work or in other cases, like other issues involving tribal sovereignty, or how that tribal sovereignty creates tensions with, other resource needs, for example? How do you see some of this playing out next?
Yeah, so one thing I forgot to mention was that the court chose not to take up this race-based issue and did actually uphold ICWA, but I believe that this issue is going to come up again, and that's shown in, so one, Justice Gorsuch had a 30-page concurrence, that 30 pages of defending ICWA, completely rejecting the non-delegation and the race-based argument. Gorsuch is actually our Indian law champion on the court, believe it or not. Kavanaugh had a less than 1 page concurrence. And all he said, in my view, the equal protection issue is serious. And he goes on to say, courts, including ultimately this court, will be able to address the equal protection issue when it is properly raised by a plaintiff withstanding. For example, by a prospective foster or adoptive parent in a case arising in a state court foster care or adoption proceeding. So he basically says, we will take this up, and then gives them a blueprint on who would have standing to bring that up. So I know this will come up again. It has a lot of different, all of these tribal sovereign, like these tribal governments that are engaging in litigation against these big projects, are doing so because they have inherent sovereignty and jurisdiction over the land that they live in. And doesn't only include reservation boundaries, it also includes areas like historical Aboriginal territory and areas where graves and artifacts and historical sites could potentially be impacted. And there's just a lot of ripple effects, and it's really connected. Like this whole webinar is all these cases, because we're talking about issues that have a lot of precedent. And this is the court where precedent doesn't seem to matter. This is the court where anything can happen, and where previous courts have been reluctant to do things like overturn Roe v. Wade or overturn ICWA. This is the court that's willing to do that. So,
Great. Yes, to state the obvious, a lot of parallels with the affirmative action case and where how the court's thinking about these issues. Thanks, Jordan. We're now going to turn over to Heather to talk about water rights.
Okay, yate everyone. It's awesome to see such a great turnout. So I'm going to chat a little bit about the Arizona versus Navajo Nation case, which was consolidated with Navajo Nation versus Department of Interior. And there's a lot of questions about what the case really goes to. Is it about tribal water rights? Is it climate change, Colorado River management? But, really the relief sought by Navajo Nation was straightforward. Does the federal government have a judicially enforceable duty to assess, plan, address, just help Navajo Nation figure out what its water needs are? And like all tribal issues, you got this a little bit, right, with Jordan talking about the history of ICWA. Context is so important. And there's a long history to consider. And again, Justice Gorsuch tends to lay out that history, and whether he's writing the opinion or in this case in his dissent. And, we go back to these seminal cases in federal Indian law, the Marshall Trilogy, that really set forth this special relationship between the federal government and tribes, that it's been referred to as a trust relationship, again, something special going on here. And then a series of treaty making with the federal government and tribes. And for Navajo Nation, there was a 1949 treaty, that basically was like, we're going to set aside some land at some point for Navajo Nation, but it included these key provisions that have been cited to over time, a promise by the government to pass laws for the happiness and prosperity of the Dene people. And then what was much more focused on the case was the 1868 treaty, which actually established the Navajo Nation reservation. And again, encourage you to really, this is a short opinion, including the dissent. We're not talking about like 100 pages and things, so it's pretty easy to read, but encourage you to read Gorsuch because he emphasizes the importance of water to Navajo Nation. And just in our context of when we were in tribal relations at the time, a lot of pressure from the federal government to be farmers, to be Christians, to give up their Indigenous identity and assimilate into mainstream society. And I'll just do a little throw out there for Derek Bitso's amicus brief that he led on the Hatahle organization of Navajo medicine, men and women, that again emphasized the Navajo perspective of the treaty and what they thought they were getting, and that of course it would have included water to thrive and survive as a community. So 68 was that last treaty, right? Treaty making era ends in the United States in 1871. And it's not that much longer when we get our Winters versus United States case, right? Key federal reserved water rights case that acknowledged tribes have a recognized right to water sufficient to fulfill the purpose of their reservation. And that case, was up in Montana. There were some upstream users that are doing these diversions, and the United States brought that action to ensure, as the trustee on behalf of the tribe, to ensure that they got sufficient water for the purpose of their reservation. So we get that really, again, key language, recognizing that the treaty with the tribe had established a reservation as a permanent homeland. You can't have that without water. There was an explicit language in the treaty with that tribe saying they are entitled to X amount of water, even really an explicit entitlement to water, but it was implied with the promise for a permanent homeland. And that's where we get our basis of all federal kind of Indian tribal rights. So I want to share real quick just this news article. So again, background of this case, absolutely water is short in the West, and climate change is making it worse. We do not have enough water to meet everybody's needs. And this GRIST article, I think, did a really great job outlining what the tribal interests are. So I put, again, GRIST was last year. Google this, you can find it, and you'll see here's our Colorado River Basin, 7 states, right? We're doing also with Mexico and the United States. And then in that basin, 30 federally recognized tribes. So a lot of people competing for water use, and the recognized tribal water rights account for roughly 25% of the Colorado River Basin. And so anyway, really encourage, great article, breaks down like how water's used, and even within that 25% that's recognized, tribes are not fully utilizing their water rights. And so big concern right here, legitimately, the states were worried and are still worried every time a tribe quantifies their water rights or they get the infrastructure to finally utilize that water right, it's coming from someone else. But Navajo Nation is a severe water insecure land and community. This map, if you go to, I think it's NavajoSafeWater.org, you'll see the reservation here and the number of homes that lack clean water access. It's estimated 30 to 40% of Navajo homes are having to haul water from long distance. So on the flip side, we have a community, a tribe with this special relationship with the federal government, a promise, a contract that they would have a permanent homeland, a place where they could thrive and prosper for future generations. And yet they've been overlooked in the establishment of water. And so, Navajo Nation brought this case decades ago in 2003, started out as a NEPA claim. And then through amendments, they brought this breach of trust claim, again, kind of rooted in their treaty, rooted in the special relationship between the federal government and the tribe. And in a split decision, 5-4, I've got to say, after the ICWA decision, I was crossing my fingers, but unfortunately it did not pan out the way that so many of us were hopeful that did. But 5-4 majority found that treaty, that 1968 treaty, it reserved water rights for the tribe. They have the ability to go out and secure those water rights and access to the water. The federal government doesn't have to do anything to help. Very disappointing. So there was not, in their opinion, that explicit language that was necessary. So where does that leave us? I'll let the questions take us there.
Thanks, Heather. I'm curious if you could give us a sense of how you see some of the water insecurity or other resource insecurity issues playing out in the future. Are there cases you're watching or sort of factual developments that you're seeing that we should be looking out for?
Yeah, so again, like the case would have been so exciting if it had come the other way, because it would have been a new tool, right? A lot of tribes are struggling with water insecurity, especially in our Colorado River Basin. Navajo is not the only one. You can look to Southern Ute, Ute Mountain Ute, Hopi, White Mountain Apache, a lot of tribes that don't have the infrastructure to access their water. And so the case would have been a great, again, what I call a new tool to help fill that water gap. In the absence of it, tribes are going to continue to do what they're doing. They're going to, those that haven't settled or adjudicated their water rights, will try and get them quantified. And then I do have to, acknowledge the IJA and IRA, Infrastructure Investment Jobs Act, Bipartisan Infrastructure Law, whatever you want to call it, and Inflation Reduction Act had a huge amount of money that went into tribal water infrastructure programs under different federal agencies. And so that's where I think right now a lot of tribes are focusing in on how can we get that IJA and IRA money. And again, another up in funds for the interior to settle tribal water rights. So we'll get there. It's just, it would have happened, I think, faster had the opinion gone the other way.
It's unfortunate. Thank you for that, Heather. We're going to turn to Andrew. Thanks, Andrew.
Hi. Really thanks to Taproot Earth and to my fellow panelists and the audience for all the important work that you do. I'm going to pick up on a couple of themes from the prior panelists, and one is sort of the targeted effort by the right to advance its agenda, whether that's in federal Indian law or racial equity. I'm going to focus on administrative law and what's happening in that space, where there's also a focused sort of right-wing agenda. I'm going to talk a little bit first about this major questions doctrine, which it can be very hard to define. And I think how I'd like to start defining it is with some examples of some cases that I think are understood to be to sort of define the term. Everyone who sort of talks about this, who's ready to acknowledge the existence of this doctrine, would talk about a few cases. And the first goes back to 2000. It's called Brown and Williamson, and it has to do with the FDA's authority to regulate cigarettes. And the Supreme Court says the FDA lacks the authority to regulate cigarettes because the FDA regulates under the Food, Drug, and Cosmetic Act, and cigarettes don't fall neatly into any of those categories. So it was a reach, an overreach by this agency to attempt to regulate for our health, right? For the best of all possible reasons, but an overreach for FDA to take that on. And the next case I would mention is one that sort of falls maybe a little bit in between. And that's a case called Gonzalez versus Oregon, where the Justice Department sued the state of Oregon under its authority for the Controlled Substances Act, basically for drugs. Illegal drug use is the statute gives them authority. And they sued Oregon to prevent Oregon's Death with Dignity Act from taking effect, right? Basically saying you can't use these drugs for assisted suicide. And the Supreme Court says now that you're out of your lane there, Justice Department, John Ashcroft, you're out of your lane. That's not what Congress had in mind when it gave you authority to promulgate regulations about certain kinds of narcotics. And then the third case, more recently, from the court's quote-unquote shadow docket, is a case brought by Alabama realtors against the Center for Disease Control on CDC's eviction moratorium during the pandemic. Again, incredibly important public policy effort to keep people in place during this public health crisis and emergency. But the court says unanimously, CDC, you're out of your lane. You don't have the authority to enact an eviction moratorium. You have authority to over many aspects of public health and pandemics, but it doesn't reach so far. And you can look at these cases and sort of say, from a public policy reason, there are arguments for and against what the government does. But I start there because they sort of define sort of what I think at the base level, what MQD is, which is government sort of out of its lane, out of the authority that Congress has delegated to it. The problem is that the conservative majority of the court, egged on by a lot of conservative organizations, has sort of taken this concept and run with it in all sorts of unhelpful ways, right? And the case I want to focus a little bit on is the West Virginia versus EPA case from 2022. This is a climate case, right? And I want to come back to that in a second too. I mean, Heather's talk is so important because we are going to be increasingly faced with water scarcity. Communities are going to feel those burdens as a result of climate change, and the government should do something. I think we can all agree on that. And the Obama administration took on this aggressive effort in the so-called Clean Power Plan to address climate change from power plants. And they were very original in their thinking about this, and sort of attempted to move plants in the broadest possible way from thinking about this issue solely in terms of at the stacks, right? In terms of transformation to green energy. And the court said, you lack the authority to sort of think outside the fence line of a power plant. Congress didn't give you that authority. And so your effort fails on major questions doctrine. And I think this case is of a different piece from the three examples I gave you in terms of a very clear charge from Congress in this clean air space. And so we see how these sort of outlier cases involving cigarettes or assisted suicide have now become sort of moved into an attack on government being ambitious. And that's sort of a theme of my brief talk to you today. We have to counteract that effort. And so this term in 2023, the court decided the student loan case. And here again, the challengers to the forgiveness of student loans says it's so much money. It's $400 billion. It's an enormous amount of money. If Congress wanted you to have this authority, they would have clearly given it to you. So this is a major question, and it must fail on that basis, sort of big picture, right? And there's a lot of problems, like law, as you all know, because I'm talking to a group of lawyers. It's complicated, right? And textually, it seems pretty clear that Congress gave the federal government a pretty wide latitude here. And the court is just sort of in some ways reacting to a public policy decision it doesn't really support. But West Virginia, the Biden student loan case, Nebraska versus Biden, we still don't exactly know what this doctrine is. It's becoming something way more potent than you're clearly way out of your lane doctrine. And that's what we have to, as public interest progressive movement lawyers, have to fight against. And there's a glimmer of hope here in terms of the Nebraska case, because it's clear on its face from those opinions that the justices themselves don't really understand what this doctrine is. For some of them, it's clearly, I just don't like this. And that's the criticism that Justice Kagan has leveled. But for others, like Justice Barrett, she's clearly trying to fit it into her overall conservative beliefs, and she's pitching a more mild form, that it's about context. And if we as advocates sort of say, like, come back again and again to a narrow construction of major questions, we may be able to do something that's really important, which is we need a government that is ready to take on big problems. And those problems are climate change, they're the burdens imposed on environmental justice communities, they're income inequality, they're the threat posed by artificial intelligence. You know, we need a government that is empowered to work on these issues. And the major question doctrine is a tool used by haters to keep government from taking on big problems. And we need to conceptualize it in our advocacy as a more narrow doctrine. And I think Justice Barrett, I commend to you her concurrence, where she sort of says it's about context. And in some context, you can see government overreach. And if we wrap the government's hands for what is genuinely overreach, maybe that is a narrow construction of this threatening doctrine. I do just want to say that you all are aware that the Chevron doctrine is up under consideration, probably be argued in December in a case called Loper Bright. And this is another effort to sort of hamstring the government, right? We're familiar Chevron doctrine. Congress gives agencies authorities, they pass rules and policies. Congress isn't super clear. This Chevron doctrine says, is it reasonable or not, right? And if it is reasonable or not, it's sustained on a pretty low bar. And that's important because we ask government to do a lot and we count on their expertise. So this is a case that's very much worth watching. And I will just say, we may be able to talk a little bit about it in the questions. There's a few reasons for some hope that I can address in the questions. And then finally, it's worth noting that probably the worst environmental decision of all time was decided last term in the Clean Water Act case, Sackett, which is really furthered the right-wing agenda of constraining the government's authority to regulate water that exists outside of channels of interstate commerce. And I will stop. It's a pleasure to talk to you, and thank you all for the work that you do.
Thanks, Andrew. You talked about how we should frame these issues in our advocacy, and I'm curious on things like challenges based on major questions doctrine or other attempts to limit the authority of agencies to handle significant problems we're facing, particularly in environmental justice or in the climate crisis. Do you have advice for advocates on how to think about these arguments and how to frame arguments around this?
Yeah, this is something I'm thinking a lot about. And so I have some maybe some signage. And I think we're all going to have to keep, there's no like magic bullet here. We all need to keep thinking about it. And one thing that we need to keep thinking about is for all of us in this space, we need to be paying attention to what the right is doing on all of these issues. That's why this webinar is so important. But I think the one thing to do is sort of like think about the language that we shouldn't back off asking the government to be ambitious. That's the right's agenda, right? They want to render government sort of toothless. And as people in a community and as advocates, we need government to address our problem, to address the incredible problems that we're confronting in climate and everywhere else. And I think we just need to think about being smart about that, which is one, keep holding the government's feet to the fire, and to be ambitious, put the roadmap ways for them to sort of say, this is what you've always been doing. This is in your wheelhouse, and to ask them to think in those ways. And secondly, I think we need to remember that sometimes the government is going to need to take on big things and not announce that it's doing it. In politics, there's an inclination to say, I'm doing something transformative. I alone can fix this, and we have done something remarkable here. And I think what we need to do is push government and get them to do things, and don't also sort of like we tell government to back off, sort of like we've done something transformative that draws attention of the right. All of those statements end up in court. Keep being ambitious, keep pushing them, but think carefully about the language and the history and the wheelhouse.
Yeah, I think that's completely right. A lot of things that are framed as bold, big action are actually exactly what we expect the government to be doing. But politicians want to take credit and make clear that they're meeting their campaign promises and things like that. But a lot of this is pretty standard work that I think should be, it's hard to strike that balance. So thank you all for those presentations. I really appreciate it. We have about 25 minutes for questions, and I'm just gonna start off with if any of the other panelists want to weigh in on what Andrew was discussing on the sort of attack of the administrative and regulatory state or government agencies' ability to do their job, and the court's sort of hostility to that.
I guess I'm popping up. It's a problem, right? I mean, especially because it's fascinating because I haven't seen it quite happen yet with our federal agencies in terms of tribal relations, like Bureau of Indian Affairs, Indian Health Service, getting restricted quite yet. But the concern that you can't take this statute that's not going to identify everything that's possible and then limit it, I think is concerning of where it could go. And Andrew, absolutely agree with you. Government has to be held accountable on the climate change impacts. Again, the big question from our tribal cases is, what does the trust doctrine mean then? Does it mean anything? And how do we enforce that going forward? And at least the way it stands now, Congress is going to have, the one thing I didn't get to a little bit on my time was, that the kind of common law principles of the trust relationship are not being applied to the federal government, and Congress has to explicitly mention that, but we'll see where it goes. The other interesting thing about Sackett, to say I think it goes a little bit to like the impacts of communities and how we can go out and protect communities, and it's such an issue with tribes because of the removal, and so a lot of their kind of connection to land is going to be outside of their reservation sometimes, and the further you get outside the reservation, the harder it is to protect. And so again, kind of this challenge of how do we keep our communities safe, recognizing that environmental harms do not stay contained in a little area. So that's my 2 cents.
I would just sort of say that the one thing I would add with that Heather's comments really drove home for me too is like, this is a SCOTUS webinar, and the courts are just one tool for us. And so for equity, on tribal water, Congress can do so much, and we need to hold their feet to the fire, right? We know the courts are failing here, and so we need to turn to other tools. And the same for the Sackett enormously disappointing decision about the EPA's ability to protect our waters. But there's room for the states to act in this space. And so we should always now is the time with this hostile Supreme Court to look at every tool in our toolkit. And I know that we don't have, there's so much, there are capacity issues, but we should be looking at every tool, and I'll stop there.
So, because this issue came up with a few of the panelists in terms of there are cases attacking laws, policies that have been established to remedy past wrongs and acknowledge historical and current discriminatory practices, whether that's the successful affirmative action cases or the unsuccessful, hopefully continually unsuccessful challenges to ICWA. How do any of you see those cases affecting the ability to give funding and resources to environmental justice communities or to tribal communities? Do you see future attacks? How do you see some of that playing out? And this could be through funding from the IRA, Infrastructure Act, other federal resources being deployed to address some of the historical, racial, indigenous harms.
Well, I can jump in and just comment that, like, historically, we have seen the result of terminating the government to government relationship in the 1950s when the federal government entered the termination era, and the goal was to completely get rid of tribes at that time. They decided that assimilation was successful enough, and they terminated like 500 tribes in that time. And since then, only 150 of those terminated tribes have reestablished their recognition. And the result was so disastrous that they like overturned that policy within like 5 years, because like the results were so immediate. All of those resources were immediately cut off from those communities. They were immediately cut off from any of the healthcare, and this is the 1950s. So imagine now there's so many more programs, there's so many more resources flowing from the government to communities now. Like one of the more immediate impacts of having that happen would be stopping that flow of resources to communities. In terms of just the challenges themselves, I haven't really noticed or seen like ICWA being has been challenged since it was established. And a lot of a lot of groups out there are opposed to the existence of tribal sovereignty. And I haven't really noticed that affecting tribal resources, but it greatly just depends on who's in office at the time. And one of the good things about federal Indian law is that it does kind of transcend political affiliation, which is how we get someone like Ruth Bader Ginsburg, who wasn't a great Indian law champion, and someone like Justice Gorsuch, who is a great Indian law champion. But then you have someone like, potentially a really conservative president coming in that we know probably won't be prioritizing like giving resources to Indigenous communities. So it just kind of like depends on the situation, but I haven't really noticed that. But I think if the case went another way, we would see that pretty quickly.
Anyone else want to weigh in here? Okay. So we've been talking about the Supreme Court here and some of the developments and limitations that have come through cases and things that we expect. Can any of you want to weigh in on other tools we have to address the climate crisis, creative litigation, for example, before state courts on sort of challenging more holistically the climate crisis?
I would just sort of say that it's really hard to find good news coming out of the Supreme Court. So when we find any sliver, we should be happy. And I think the denial of cert in the climate accountability cases, the Boulder, City of Boulder case against Suncor, that's good news. I think the argument is that these torts cases against oil companies that are brought by states and municipalities shouldn't be in state court, that they should be in federal court, where the oil companies feel like they've got a better shake and a more direct path to the Supreme Court. The court has recently rejected those arguments, finding that they're not sort of controlled by federal common law, which was actually quite consistent with the government's long-standing position in this area. What that means is that those cases are freed up to proceed, and the advocates are getting more and more sophisticated about those climate accountability cases. So I think the recent complaint filed in the last couple of weeks by the state of California is a pretty sophisticated complaint, and we'll see what happens in those courts, but it's a way of keeping the pressure on fossil fuels, and it's an avenue that the Supreme Court hasn't shut down, so we should be happy about that.
And Andrew, quickly to follow up on that. So this is a case that the California AG's office brought against the oil and gas companies for harms created from fossil fuel extraction and processing. That is that the sort of biggest, most prominent case that you've seen that we should be watching in terms of how those cases play out?
Yeah, I think that's right. There's several cases out there by several states. Massachusetts has a case. Some of the cases that I think might be most appropriate, have the most traction. This is me personally, and I'm not a tort expert by any means, but are the deceptive practices. I mean, we know that for a long time, the fossil fuel companies understood the threats posed by climate change, and they held out to consumers sort of that there wasn't a problem or that they were working on it. And I think that there's good evidence in the record that's not true. And so I'm sort of more hopeful about some of those cases, but I would caveat all of this with the notion that I'm not an expert. But the one thing I will say about the recently filed California complaint is that it has the benefit of building on the complaints that have gone before. And I think all of the advocates have gotten more sophisticated about the causes of action here.
Thank you. So, oh, go ahead.
Can I just add on? I mean, just with the opportunity at the state level, it's obviously much easier to amend kind of a state constitution than it will be for our federal constitution. And so it's interesting to follow the cases and seeing where the constitutional right to a healthy, clean environment are going, and seeing the movement by youth and bringing these lawsuits like in Hawaii and some other states. And so I think there's a real opportunity at that level to get involved on state protections and strengthening those. Because even though ICWA was upheld, we really, before I came to California, I was in Utah, we pushed very heavily for the state to adopt its own state ICWA law, because the state has its relationships with the tribes as well, to reaffirm that and at least protect those that minimum process, notwithstanding the feds. And so I think there's kind of this dual alignment, whether you work on kind of federal level policy, but also to be in connection with what's happening at the state level as that kind of fallback.
Yes, I agree. And just to piggyback on your noting that the youth passion and enthusiasm for climate justice is something that's really inspiring to see right now. And it, cuts across so many different issues and really intersects with a lot of what we're talking about. And so one of these things that I know that this is very important to Taproot and a lot of its coalition members and partners is Title VI. And this is a tool that advocates have long used to raise instances in which state, local agencies, for example, are using federal funding and are in some way impacting people on the basis, negatively impacting people on the basis of race or other protected characteristics. And so we've seen some recent developments there. Kara, I was hoping you could talk a little bit about what we're seeing on Title VI, any connections you're making with the affirmative action cases, but how sort of the disparate impact analyses that that we've relied on and the government's relied on to ensure that federal funding is being justly spent, how that's playing out.
Sure. So just to back up, so Title VI, as Andre just mentioned, is the statute passed in 1964 as part of the Civil Rights Act that says that it is legal to discriminate on the basis of race, and it bars not only intentional discrimination, but also disparate impact or results discrimination. And it applies not only, it's most known in the education context, and as I was talking about, there was a Title VI claim in the affirmative action litigation, but it actually applies to all federal agencies have a duty to implement the the disparate impact regulations under Title VI, and private plaintiffs have the right to bring disparate impact claims, even though before agencies, you can bring a Title VI disparate impact claim, even though under Alexander v. Sandoval, there's no longer recognized a private right of action to bring a Title VI claim in federal court. So this is a critical tool for ensuring that the purpose of Title VI is carried out in terms of ensuring equity in terms of funding, but also in terms of other impact. And it especially because it has become so limited in terms of the ability to bring claims in court, being able to bring an administrative agency complaint is even more critical. So we've most recently seen this case in Louisiana where the Attorney General is attacking the viability of disparate impact liability through administrative claims. And it's a concerning pattern. We've seen the rollback of Title VI in so many other areas, most famously through Washington v. Davis and Arlington Heights, following it and under the Equal Protection Clause. But we've seen attacks, as I just mentioned, through Alexander v. Sandoval. And so we see this limitation and rollback of Title VI happening on all fronts. And so, these cases are critically important for us to be watching and pushing back against. And I think, again, taking the reminder of not all action that matters for the future of this legislation should be focused on courts, right? We should be looking to Congress as well. But this is a critical tool really to ensuring that systemic racism and inequality isn't not only just further embedded as the status quo, but also isn't actually furthered by federal agencies. That was the original purpose of Title VI, right? Was to ensure that the federal government wasn't reinforcing discrimination and inequality through its provision of federal funding.
Thanks, Kara. And we're seeing some of the states aggressively take that on and want to disable the federal government's ability to ensure that federal funding is being equitably spent and not spent where harms are being created. So I'm going to actually flip it back to you again, Kara, because we didn't get enough time to talk about redistricting. I think everyone is anxious about upcoming elections and how things are playing out. We had a surprising decision this summer on redistrict. So I'm hoping you could talk a little bit about that case and what you see coming up in the next year or so.
Well, it's funny when we're calling surprising cases that are reaffirming the law as it stands, right? But Milligan was an important case reaffirming the viability of Section 2 of the Voting Rights Act. It dealt with Alabama's redistricting. And although Alabama, in defiance of the Supreme Court affirming district court's decision that its redistricting plan discriminated against African American voters by diluting the vote of folks who have historically lived in the Black Belt in Alabama and whose votes were diluted through Alabama's redistricting plan. Despite the Supreme Court affirming the district court's decision, Alabama then tried to really defy the Supreme Court in not addressing the discrimination that was found in its subsequent plan. And now the Supreme Court has again said, no, really, Alabama, you need to address this discrimination. So I think we're gonna continue to see potentially challenges in different contexts to Section 2, including in this term. And I just want to emphasize part of why Section 2 is such a critical tool and why we have to be so vigilant and focused on continuing to defend it is because of the Supreme Court's decision in Shelby County v. Holder really gutting Section 5. And so that's why we have such limited tools available. We don't have the preclearance protection that we used to have. And just to make the full connection, again, Shelby County was a case that Ed Bloom was really the architect behind. So we see a through line, and we need to recognize the through line because, I think the right and conservatives are not being siloed by issues, but really thinking about about an attack on race consciousness as pervading and being pervasive between different substantive areas. And so we need to be thinking the same way, right? We need to be thinking about the connections between different substantive areas, the connection between different groups and how to be allies for each other, because an effective response, but also an effective vision of how we want to move forward as progressives requires that.
Yeah, and I think one thing to note for why is predominantly environmental justice community talking about these redistricting cases, and I think the answer is likely fairly obvious for most of us. Indigenous communities, Black and Brown communities have long borne a disproportionate amount of environmental harm, and also a majority of voters agreed that climate change is an enormous issue, and our politicians should be working towards solutions. And if those voices are unable to be heard because they're gerrymandered away and carved into districts where their full voice isn't heard, and that's a problem that we're going to have to ensure that we have elected officials who represent what needs to change. So before I throw it back to Amy for her final thoughts, and to wrap us up, I want to ask any of the panelists if you have final words for us.
I'll just say there's a lot of opportunity for people to not just take on pro bono cases, but to be engaged. We've introduced a resolution in the Senate to reaffirm the trust responsibility if senators, or call up your senator, right? This whole engagement in our democratic process is so key. Encourage. So even if you are not Indigenous, or you don't, are from the communities most in need, there is a lot of help that you can still do. And it doesn't have to be in court, going back to Andrew's comment. So thanks for having me. Yay.
I'll add my final comment just to say that what Kara said about looking at who's really behind what's going on here is going to be really important. So what you'll see is there's a lot of interconnected organizations and people with a lot of power and resources that are behind some of these big cases, like whether it's Ed Bloom or the Goldwater Institute or Enbridge or Chevron, or these companies and people that are all connected to each other, and looking behind who's funding this, who's really the catalyst behind this, and exposing that. And my last thing is, if you want the quick and dirty education on federal Indian law, then you should read Oklahoma versus McGirt opinion that was written by Justice Gorsuch. In about 60 pages, he goes over an entire history of Indian law and actually does a pretty good job. So if you're not familiar with tribal sovereignty in this country, or you just want to learn more and understand the cases behind it, start with Oklahoma v. McGirt. So.
Great, thank you. And Jordan, could you put that in the chat when you get a chance? The name of the case.
I guess I would just echo on a hopeful note that despite the fact that it can kind of feel overwhelming, the number of fronts that there are different attacks going on at once, it's incredible to see the way that young people are showing up as allies, are outspoken and thinking about how to push the values of equity and inclusion even farther. This has been Book Week, and it's incredible to see the work that young people are doing to ensure access to diverse learning materials and to combat hostility, even in environments where it's not easy to come forward, and it actually puts them at a danger, in danger and facing, continued attacks by speaking out. So I just want to lift up the work that students across the country are doing on all of these fronts and the ways that they are explaining to us how these issues are interconnected.
Yeah, I think Cara just said everything I wanted to say, which is that three of us on this panel are at law schools. We're energized by the work of what we see in young people wanting to take this issue off and these issues on. And for the audience, if I can send you students, or you want to want them to know about the work you're doing, please reach out. And all of us together, I think we can make progress, and I'm encouraged by the young people I work with.
Great. Thank you again to each of you for that, for the information. And I'm going to turn it back to Amy. You're on mute.
And thank you so much. Thank you to all the panelists. Thank you, Andre, for moderating us. It's so important to have this understanding of the broader landscape of challenges in the federal courts. Both the surprising cases, which, as Cara said, are really just reaffirming the law as it stands, and the places where the federal courts are constricting rights and democracy and our ability to address structural racism and uphold Indigenous sovereignty. And I'm so appreciative to you all for drawing the connections between these cases. They are not existing in isolation. And I also really thank you all for identifying areas of possibility and calling for folks to be engaged at all levels of government. It is sometimes, the Supreme Court takes so much focus, but there is so much work happening at the local and state levels as well, and real possibility there for building power. So as Andy says, we should not back off asking the government to be ambitious. We should not stop being ambitious ourselves. And I'm really grateful for this network to be building together. So thank you all for joining us. And I will tip it to the DJ to bring us to a close. Thanks so much.